control of Congress. Related to a federal purpose. Law here is over-inclusive. Take into consideration the level of generality. Majority says level of generality is high and the court should leave it to Congress to decide whether it's proper or not. Can't violate other parts of the Constitution. Can't be unduly coercive. Majority say that the law here is not unduly coercive. B/C 5% is only mild encouragement. State argues that they have no choice but to accept the money. Condition here is not related to the highway funds, O'Connor dissent. Most of these restrictions should be left up to Congress. National Federation of Independent Business v. Sebelius. Affordable Care Act application. Commerce power, individual mandate. Policy rationale. Insurers can't turn away people with pre-existing conditions. With the IM, the pool of insured enlarges and therefore the costs of insurance are spread throughout the pool. Government has the need to regulate the health insurance system as a whole. Everyone needs health insurance. If no IM, insurance prices will escalate. Court holds inactivity is not commerce. Congress is attempting to create commerce here. Wickard is the outside limit of the Commerce Clause. There is no precedent for regulating inactivity. Dissent. Although there is no precedent, that is because no case has been factually the same. Choosing not to buy a product can be considered activity. IMV. Universal health care. Medicaid for all could be considered constitutional. Open constitutional question. We should focus on the means, not the ends. Court is only willing to say this B/C. They know that universal health care will not happen anytime soon. Medicaid for all would be more intrusive for health insurance providers than the IM. A lack of limits could be problematic, if there are really no limits like the court says there are. States likely could not do this themselves because there would be problems if people attempted to get treatment outside of their state. Additionally, more likely to be equitable if federal government manages this B/C. There is a larger pool of people. Also, states don't want to do this themselves and it doesn't interfere with the current affirmative state policy. Necessary and proper clause. While the law may be necessary, it is not proper here because there is no relevant enumerated power that can sustain the law. Taxing power. Justice Roberts, writing for the court, holds that the IM is constitutional under Congress's power to tax. Therefore the opinion in regard to the Commerce Clause is advisory. May have done this to demonstrate his conservative tendencies or send a message to Congress about the limitations of the Commerce Clause. Limits. Roberts holds there are limits on Congress's taxing power, but does not identify any. We know there are no significant limits. B/C. We already have Medicare and Medicaid. Tax vs. penalty. Dissent argues this is a penalty rather than a tax. Described as a penalty in the statute, likely for political reasons. B/C. Congress believed they would be able to pass the law under the Commerce Clause. Dissent's arguments. Requirement. Groups of people are being excluded. The penalty is not in the title it would normally be in, if this were considered a tax. Title I not Title IX. Majority rebuttal. Enforced through the IRS and collected through the IRS, suggesting it is a tax. Must be disclosed on tax forms. Spending power. Background. Only brought in the 11th Circuit, who held the Medicaid spending provision was constitutional. Many thought the court would affirm, but they struck the provision down. No standing and ripeness problems. Two opinions. Scalia, Kennedy, Thomas. And Alito. Unduly coercive. Roberts, true holding. B/C. There is no majority and this is the CJ's opinion. Two additional conditions. Modification to an existing program, but Medicaid has been modified previously. No fair warning that this was going to be changed. But this is not required by the law, case law, or Constitution. This suggests the states must be alerted. More hurdles for Congress to jump through. Dissent, Ginsburg. Courts shouldn't decide this. Congress should have discretion in determining how much coercion is too much. How much coercion is too much? 100% is too much. Numerator and denominator are the same. Dole was only concerned with 5% of the total highway budget. Medicaid is a much larger portion of a state's overall budget. Spending power takeaways. 100% is too coercive, too much, and unnecessary. Clear here there is an outer limit. Congress chose 100% here B/C. No one was paying attention to this issue and they thought it was a non-issue. Condition in this case was directly related to the money being given, as opposed to dole where there were issues with generality, relationship between highway funds and drinking age. Federal legislative power takeaways. Congress has a number of different tools in its arsenals and the outcome of a case may depend on which tool is used. Commerce Clause. Means of transportation. What goes into those means of transportation? Activities in a state that substantially affect those outside of a state. Taxing power. Spending power. What is being done, how it's being done. And for what purpose? Which conditions or requirements are actually necessary to achieve their goals? No ACA conference committee, so many errors went unfixed or edited. No technical corrections on the bill after it had been passed. Federal limits on state power. Preemption, express and implied. Federal preemption overview. Supremacy Clause, Article 6, Clause 2. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. 2. Form of preemption. Express preemption. Congress expressly displaces state regulations of a particular subject. X. Only Congress may regulate the labels on meat. Turns on statutory interpretation to determine how far preemption reaches. Implied preemption. Conflict preemption. Implied preclusion of conflicting state and federal law. When compliance with both federal and state regulations is a physical impossibility. When state law stands as an obstacle to the accomplishment and execution of the full purpose and objectives of Congress. Mere fact that federal and state law are different doesn't mean they necessarily conflict. If the federal law is the ceiling, the standard, more rigorous state law would conflict. If the federal law is a minimum/floor, more rigorous state law is permissible. Example. Seconds of AG. Passes regulation forbidding picking/shipping of avos before a certain date to ensure quality/maturity, minimum. CA can prohibit sale of avos that contain less than 8% oil. Field preemption. Implied occupation of the regulatory field. When Congress chooses to regulate a subject exclusively by federal law. Field preemption is rarer than conflict preemption. Compounding difficulties in this area B/C. Each rule or law has to be viewed on an independent basis. Case-by-case statutory interpretation. Level of generality comes into play when interpreting federal statutes. Medical devices are preempted more broadly than drugs are. Tort law. Often federal statutes were written to preempt regulatory law, but did not keep the relevant tort law in mind when they were written. State tort laws have been significantly limited by federal preemption. Preemption is mostly used by defendants as ceilings and floors to unfavorable state laws. Congressional motives. Uniformity. This is not necessarily a reasonable justification, however, because our country was developed upon the idea of federalism and states' rights. Has potential benefits. Makes it easier and more predictable for corporations to know which regulations they need to follow. Advertising does not end at state lines. Lack of uniformity poses real-world, practical issues. Federal Arbitration Act. Some arbitration agreements have bans on class actions which are debilitating to consumers. CA state law, unconscionable. Court has ruled FAA preempted state laws concerning state bans on class action. inconsistent with the purposes of the FAA. Court is willing to find broad preemption. Silkwood v. Kerr-McGee Corp. Issue: whether a state-authorized award of punitive damages arising out of the escape of plutonium from a federally licensed nuclear facility is preempted. Either B/C it falls within that forbidden field, or B/C it conflicts with some other aspect of the Atomic Energy Act. Holding: state tort remedies are not preempted here. No indication that Congress intended to forbid the state from providing state law remedies for those suffering injuries from radiation at a nuclear plant. Silence is significant here. B/C it is unlikely that Congress would not provide possible remedies for these types of situations. Presumption against preemption. Kerr-McGee has burden of showing Congress intended to preclude state tort law damages. This doesn't really mean anything though. Exclusive authority to set safety standards did not preempt the use of state tort remedies. Punitive damages actually reinforce the federal interest. Primary conduct. Is state law affecting the primary conduct of Kerr-McGee? State law is not affecting the primary conduct of Kerr-McGee. B/C This is not a new rule, but rather additional consequences for deliberate violation of federal law. Price-Anderson Act sets outside limits on the payouts for nuclear disasters in state tort claims. This is an absolute granting on permission for state to use their own tort law. Field preemption. No field preemption in the case of nuclear energy. Field preemption in National Labor Relations Act/Board. ERISA. U.S. Term Limits Incorporated v. Thornton. Facts: Arkansas adopted a term limitation amendment to their state constitution which provided that House members from the state could only have 3 terms and senators could only have 2. Doesn't preclude them from being elected, just precludes them from being on the ballot. Citizen, resident, taxpayer, and registered voter filed a complaint seeking declaratory judgment on the amendment. Holding: this act is unconstitutional because voters are still being precluded from voting for their preferred candidate. State is trying to indirectly do what can't be done directly. If Congress can't do this, it is likely that the states can't do this either. This power is not retained by the states. Only can retain powers that were theirs in the first place. Didn't have the power to make qualifications for the legislature during the Continental Congress or the Articles, so they don't have that power now. Qualifications. These were already considered by the founders: age, etc. Minimum qualifications are not protections for the states, but rather for the good of the country as a whole. Rationale against term limits. Takes time to get used to the jobs and how to operate within Congress. There are already express term limits in the Constitution. Qualification were already expressly considered by the founders: age, etc. Minimum qualifications are not protections for the states, but rather for the good of the country as a whole. Method of argumentation. Structure of the Constitution. Then look to other provisions of the Constitution to see how to rule on this provision. Dissent. States have power unless it is prohibited or it is enumerated. At the time of framing, states has many qualifications to run for office. Therefore, in the absence of prohibitions, we should assume our states have power to impose qualifications. Ex property qualification. 2. Dormant Commerce Clause. Dormant Commerce Clause, DCC, Overview. The grant of power for Congress to regulate interstate commerce imposes several implicit restrictions on state regulations of commerce. The court has struggled to define the precise contours of these limitations. However, currently, states cannot treat differently from interstate commerce when there is a reasonable, non-discriminatory, alternative way of furthering the state's legitimate interest. Legitimate local interests include protecting health and safety and conserving the natural resources. They do not include protecting local business from competition. Additionally, a state cannot impose a burden on interstate commerce that is excessive in relation to legitimate local interests. Affirmative grant of power has been interpreted to be a negative barrier to states doing certain things that impact Congress. Congress has not stepped in. Commerce Clause places limits on what states can do in the absence of congressional action. Local subsidies. Are they a good or bad idea? Are they constitutional? Court seems to say direct subsidies are okay, but we don't know exactly why they believe this. Questions to ask when analyzing DCC issues. Who is being harmed? Local citizens who are paying more? Competitors who are shut out? Who is benefiting? Alternative means. When should the court step in? Cooley v. Board of Wardens. Facts, pilot fee, or fine, for interstate ship commerce. About the local conditions of the port and the safety of the people in that port. Not concerned about that singular vessel, but rather the safety of everyone in the port more generally. Holding, the mere grant to Congress of the power to regulate commerce did not deprive the states of power to regulate pilots, and although Congress has legislated on this subject, its legislation manifests an intention, with a single exception, not to regulate this subject, but to leave its regulation to the several states. Uniformity. This argument can be too broad. States would all end up exactly alike if all was uniform, defeats the purpose of federalism. Act suggests that Congress doesn't care about uniformity in this area. Wabash, St. Louis and Pacific Railway Co. v. Illinois. Facts, state law allows for price discrimination for interstate railroad rates. Illinois could do this within the state, but not out of state or between states. Slippery slope. If one state could do this, all others would. Therefore Congress should regulate. Holding, state loses. Court claims that multiple states are partaking in this practice, but provides no evidence. Difficult to see the constitutional basis for ruling that the state can't do this now. Court seems to be anticipating a problem without an actual basis for doing so. South Carolina State Highway Department v. Barnwell. Facts, state law holds that you can't have any truck that exceeds 90 inches and can't have trucks whose weight exceeds 20,000 pounds. Trial court strikes down weight limit and increases width limit to 96 inches. State law significantly limited interstate commerce in South Carolina. Holding, regulatory measures taken by South Carolina are within its legislative power. Rule, state legislature may impose burdens on interstate commerce so long as it has acted within its province and the means chosen are reasonable. However, modern cases ask whether the burden on interstate commerce is excessive in comparison to legitimate local interests. Although the court here establishes the former rule, they proceed to analyze the case using the modern approach. Outliers. Should we take into consideration the fact that South Carolina is an outlier? Is it unfair to make them change their rules simply because they are the most restrictive? Doesn't one state always have to be the most restrictive? Because they are the most restrictive, it is necessary to look more deeply into the considerations as to why SC enacted these laws. Interstate vs. Intrastate roads. This law does not necessarily favor local over interstate commerce. Example of discrimination would be different rules for SC trucks and out-of-state trucks. Has to be facially discriminatory. Different than an undue or excessive burden. In this case SC trucks are subjected to the same rules as the out-of-state trucks, they probably don't this rule either. Therefore probably not local protectionism. Burden vs. benefit. Weight. Difficult for the court to determine a bright line rule for the appropriate weight. Width. Weight question was subjective, but here the width is an objective determination. We know the exact width that can fit on the road. 4 inches does not make a difference when it comes to being able to see around a large truck. Southern Pacific Co. v. State of Arizona. Facts. AZ state statute limited the number of freight and passenger cars could be connected on a train. Holding, state interest cannot be preserved at the expense of the national interest by an enactment which regulates interstate train lengths without securing such control, which is a matter of national concern. To this the interest of the stater is subordinate. Facial discrimination. No, but could still be discriminatory. B/C out-of-state trains have to disassemble and reassemble while in-state trains don't. Additionally, AZ trains don't have to make changes when they go to other states, but trains coming into AZ would be in violation. Safety. More trains on the railways to carry the same amount of goods causes more accidents. Disassembling trains is dangerous and creates more of a safety issue than the long trains. If state was so concerned with safety, look at what else they were doing for the safety of workers and etc. Nothing here, which undermines the notion that this was a safety issue. Castle v. Consolidated Freightways. Facts: state attempts to regulate length of trucks, contending longer trucks are less safe. Holding: statute violates the Commerce Clause because Iowa has imposed this burden without any significant countervailing safety interest. Safety. State has not demonstrated that safety is actually at issue here and that there is an actual difference in safety between trucks that are 55 feet long and trucks that are 65 feet long. The court is not making a determination on the proper length of trucks. Evidence was presented at trial that there was no difference in safety between 55 feet and 65 feet trucks. Accidents were directly proportional to the number of miles driven, therefore if there were more small trucks, there would be more miles driven and more accidents. Effect on interstate commerce. Long trucks would not be able to cross state lines. In-state trucking companies will purchase shorter trucks. Out-of-state trucking companies will drive around the state, thereby spending more time and money than they would have. Iowa's actual motivation: lowering maintenance fees on their highways. Legislative history suggests this is the true motive. However, dissent argues it is impossible to know the intent behind each individual legislature. Weight problem is similar to Barnwell, but can be distinguished. Statutory exceptions. Suggests safety is not the true reasoning behind the Iowa statute, the exceptions are not necessarily consistent with safety motives. Border cities are exempt. Border areas are not entitled to be less safe. Border cities just want to sustain levels of commerce. Livestock exemption. Farmers would want this. Cuts against safety. Preventing protectionism. Dean Milk Covey. City of Madison. Facts: Madison City Ordinance was passed that attempted to regulate the sale of milk and milk products. Unlawful to sell milk as pasteurized unless it was processed and bottled at approved pasteurization plant within 5 miles of the city. Prohibited the sale of milk in the city unless from a source that was inspected by Madison officials, but these officials only have a duty to inspect farms located within a 25 miles from the center of the city. Holding: ordinance imposes an undue burden on interstate commerce. B/C The regulation imposes an economic barrier protecting major local industry against competition from without the state, which the city cannot do, even in the exercise of its unquestioned to protect the health and safety of its people, unless no reasonable non-discriminatory alternatives are available. However, in this case, reasonable and adequate alternatives are available. Court only rules on the 5-mile regulation. Reasonable alternatives. No one was dying in Chicago or other cities that were attempting to provide milk to the city of Madison. Federal inspectors are neutral experts and therefore the court does not have to make evaluations. Economic effects. Out-of-state dairy farms would lose if the ordinance was upheld. Consumers inside Madison would also lose if ordinance was upheld. B/C There would be less competition inside the city and therefore the prices would have been higher for milk and other dairy products. City of Madison doesn't have the right to exclude others from their economy. We want a national economy without artificial barriers. Hughes v. Oklahoma. Facts: Oklahoma statute provides that no person may transport or ship minnows for sale outside of the state which were sent or procured within the waters of the state. Statute is facially discriminatory. Oklahoma contends that the statute serves a legitimate local purpose as a conservation measure. Holding: court finds the statute to be unconstitutional. Far from choosing the least discriminatory alternative, Oklahoma has chosen to conserve its minnows in the way that most overtly discriminates against interstate commerce. Reasonable alternatives. Here, there are reasonable alternatives, but in Maine v. Taylor there were not. Maine v. Taylor, PG 301-02. Prohibition on bringing non-native species into Maine was upheld. No reasonable alternatives. No exceptions. In light of the justification offered. Conservation. Selling naturally born minnows out of state would deplete the minnows. However, nothing in the record to show that naturally born and farm-raised were different. No limits on in-state sales. City of Philadelphia v. New Jersey. Facts: New Jersey law prohibits the importation of waste which originated or was collected outside the territorial limits of the state. Operators of private landfills in New Jersey had agreements with out-of-state operators for their trash. They sued New Jersey and its DEPT of EP. Holding: law invalid because it is a facially discriminatory law which promotes protectionism. Compared to Dean milk. Private landfill owners milk consumers. People who want to send garbage out of state milk providers. Environmental protection. State claims they want to keep garbage out for environmental reasons. Exceptions for swine: this doesn't tell us much though. Court holds that one state can't isolate itself from a problem that is common to many. Free commerce is better overall for the nation. Camp Newfoundland/Owatonna v. Town of Harrison. Facts: state property tax exemption for property owned by charitable institutions excludes orgs. Operated principally for benefit of non-residents. Holding: for purposes of Commerce Clause analysis, any categorical distinction between the activities of profit-making enterprises and non-for-profit entities is illusory. Entities in both categories are major participants in interstate markets, and although the summer camp involved in this case may have a relatively insignificant impact on the commerce of the entire nation, the interstate commerce activities of nonprofit entities as a class are unquestionably significant. Public policy. Public policy is being made through tax law. Is this still subject to the DCC? Out-of-state buyers are spending more to ship their kid to camp because of the denied tax subsidy. States vs. Private entities. DCC has traditionally only applied to the states, tells states what they can't do, not private entities. Court seems to be expanding the bounds of the DCC here. Dissent. Scalia: nothing wrong with giving benefits to local business and they can subsidize kids coming from Maine going to camp. Thomas: no basis in the text of the Constitution for the DCC. Facial discrimination is less troubling. Problem with this argument is, as a textualist, all DCC decisions would need to be overturned. Congress would have to step in. Westland Creamery Incorporated v. Healy. Facts/holding: court invalidates a Massachusetts law that imposed a tax on all sales of milk to Massachusetts retailers, but then rebate the proceeds of the tax to Massachusetts dairy farmers, even though 2/3 of milk sold in Massachusetts came from out of state. Subsidies vs. Taxes. Court admits the Scalia's contention in Camp New found that this would be okay to do through subsidies, rather than taxes. What are the differences between the subsidies and taxes? Politically easier to do it this way. No economic difference. Why is there a constitutional difference then? Court has been unwilling to confront the problem in these two cases as to why it's okay to directly subsidize, but cannot do this indirectly through taxes. Market participant exception. South Central Timber Development Incorporated v. Vunick. Facts: Alaska DEPT of Natural Resources published notice that it would sell timber with the special provision that successful bidders/buyers must partially process the timber prior to shipping it outside of the state. Stated purpose is protecting existing industries, providing for the establishment of new industries, deriving revenue from all timber resources, manages the state's forest on a sustained yield basis. If state is acting like a market participant, rather than as a market regulator, the DCC places no limitation on its activities. Hughes v. Alexandria Scrap, State as purchaser. Facts, makes it more difficult or expensive for out-of-state suppliers of cars to sell them to Maryland. State is the buyer. The current case is distinguishable from Alexandria Scrap B/C. Maryland was the purchaser of scrap metal, and here Alaska is imposing downstream conditions on the timber processing market. Reeves Incorporated v. Stake, State as seller. Facts, court upheld a South Dakota policy of restricting sale of cement from a state-owned plant to state residents, relying on the long-recognized right of trader or manufacturer engaged in an entirely private business, free to exercise their own independent discretion. Although Reeves endorsed the right of a state to deal with whomever it chooses when it participates in the market, it did not purport to sanction the imposition of any terms a state might desire. This case is also distinguishable from Reeves in that three major elements not present in Reeves are present here: foreign commerce, natural resources, and restrictions on resale. Here, state can choose who they wish to sell to. We should treat the state like a private business. White v. Mass. Council of Construction Employers Incorporated. Facts, court sustained an executive order of the mayor of Boston which required all construction projects funded in whole or in part by city funds to be performed by a workforce of at least 50% city residents. City is paying the contractors here, therefore it is okay for them to enforce its preferences. If this law is struck down, the city would just hire workers directly, same economic effect. Restrictions on resale. Is this the same as the White case? No, what the state is doing here is more similar to controlling private business. Court says state could directly subsidize the processors here, but their reasoning behind this is unclear. Dissent, the distinctions the majority makes are arbitrary and artificial. United Haulers v. Oneida Herkimer Solid Waste. Facts, flow control ordinances required haulers to bring waste to facilities owned and operated by a state-created public benefit corporation. Holding, disposing of trash is a traditional government activity, and laws that favor the government in such areas, but treat every private business, in and out of state, exactly the same, do not discriminate and are permissible under the DCC. Any incidental burden these ordinances might have on interstate commerce don't outweigh benefits they confer on the citizens. Rationale. Law requires that all solid waste go to state facilities. Economically inefficient. If not every hauler was tipping in the same place, counties need to cover their costs. This is not about economic activity or protectionism. State is attempting to achieve their environmental goals. State is not really engaged in protectionism. B/C. The state is not subsidizing third parties. DCC doesn't require state to give up all of its other goals. Additionally, hard to determine an alternative way to achieve the same goal. Relevance of law being supported by voters. Voters decided to make a trade-off. Pro-environment benefits for possible increased cost of hauling. Less reason to be concerned than in Westland Creamery. Pike balancing test, plurality opinion. Uphold a non-discriminatory statute unless the burden imposed on interstate commerce is clearly excessive in relation to the putative local benefits. Scalia, concurring in part. DCC should only be upheld on stare decisis grounds in two situations. Facial discrimination. Extremely similar prior cases. Thomas, concurring in the judgment, states should have the ability to do what they want. Dissent, this is the same as Carbone, which was invalidated by the court, and we should stick to our precedent. 3. Interstate taxation. Overview. Tax against a Commerce Clause challenge if applied fairly to activity with substantial nexus to taxing state. Fairly apportioned, can't be taxed twice. Doesn't discriminate against interstate commerce. Fairly related to the services provided by the state. Quill v. North Dakota. Facts, ND law requires sellers to collect use tax if they had minimum contacts with ND, even if they had not actual presence in the state. Before Quill, sellers did not have to collect use taxes if they did not have an actual presence within the state. ND asking court to overturn Bella Hess because of the changing times. ND argues Bella Hess was wrong and should be overruled. Change in the law and economy since Bella Hess was decided. Dormant Commerce Clause. Court upholds Bella Hess on the DCC issue. A tax can only be imposed if a company has facilities within the state. This allows the company to pick and choose where they want their facilities based on the benefits of the law, including labor laws, unionization, usury, etc. Facilities therefore will not be spread out evenly. Due Process Clause. Regulatory due process rather than PJ. Regulatory due process is more burdensome b/c. You have to follow all the regulations of all states. Court overrules previous due process holding. Court goes to the trouble here of overturning the DP aspect b/c. The DP aspect and the DCC aspect are different types of constitutional rules. DCC can be overruled by Congress. They can regulate this issue if they want to. Majority's reasoning. Stare decisis is important here. Practical benefits. Bright line rule is helpful here b/c. There will be less litigation in the courts. Companies know where they will and won't be taxed. Primary conduct. If you don't build a building in CA, you won't be taxed in CA. Does National Geo case undermine the bright line rule? No, b/c. It is impossible to eliminate all litigation. Will always have problems at the margin. Safe harbors allow companies to know the effect of their actions. Not worried about ND, but rather all of the 6,000 taxing entities. Extremely burdensome for Quill. Retroactivity. Will states/companies want to collect retroactively? Probably not. Court doesn't decide on this problem. Is it appropriate for them to stay silent here? Not really. Scalia argues that retroactivity is not in the question presented and therefore should be left for another day. Marketplace Fairness Act. Congress cannot add/change many things that the court would not be able to do. Additional hoops. Centralization. Requirements that legislation can impose. 6. Privileges and Immunities Clause. Privileges and Immunities, PNI, Clause Overview. Article 4, Section 2, Clause 1, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Designed to prevent discrimination against citizens of other states. DCC deals with facial discrimination and discriminatory impact. Framers knew how to deal with discrimination problem explicitly, so there was no need for court to make it up through use of DCC. Complete overlap between PNI and DCC? No. X. Castle, everyone was subject to the same rules, no facial discrimination. PNI doesn't deal with undue burdens imposed on interstate commerce. Court has ruled that corporations are not protected by PNI because they are not citizens. But the purpose of PNI is to protect against discrimination. Why should corporations lose this protection? What does citizen mean in this section of the Constitution? Inconclusive when looking at this portion of the Constitution. Article 3, Citizens includes corporations. Why is there a difference between citizens in these two different articles? Considerable overlap between DCC and PNI, however, in comparison with the DCC, there is a clear line in regards to PNI. Fundamental rights, travel, reside, business, property, tax discrimination. Baldwin v. Fish and Game Commission of Montana. Facts. Court only heard this case because they had to, they didn't care about the issues, hunting licenses and low amounts of money. Terrible case to begin with. Equities were against the plaintiff. They merely did not want to pay, they had the money to. Holding, fundamental rights are protected by PNI clause, but mere recreational rights are not. Textualists argue PNI says all and therefore recreational rights should be included as well. If you read PNI literally, it says all, which suggests it doesn't literally mean what it says. B/C Not all citizens retain the right to vote. Incidental impact on out-of-state citizens is okay. Fundamental right argument has weaknesses though. X. College admission/tuition prices. Doesn't violate PNI because if all states can do the same thing, it is essentially equal. Preference to its own citizens. Market participant doctrine. Schools are essentially selling their services and therefore they have some discretion in choosing who they sell their services to. Supreme Court of New Hampshire v. Piper. Facts, had to be a resident of the state to be admitted to the bar. Holding, the court strikes down the law. NH has no substantial reason for difference in treatment and means chosen do not bear the necessary relationship to their objectives. Separation of powers. I. Presidential domestic powers. Overview. President has no right to make laws. Power must stem from an act of Congress or from the Constitution itself. Youngstown Sheet and Tube Co. v. Sawyer, steel seizure case. Facts. During the Korean War, Truman sought to avert strike in steel industry, so he issued an executive order directing the Seconds of Commerce to seize the steel mills and operate them under federal direction. 2 statutes could have been used to take action, but abiding by their provisions was too burdensome. Congressional approval of order was not requested. Steel companies sought injunction to prevent seizure. Holding, court struck down executive order as an unconstitutional exercise of executive lawmaking. Can't be justified as military power because it was outside the theater of war. Can't be justified as faithful execution because executive is making the law. Is the executive order a law in this instance? Is it structures like a statute? Rightward arrow no. Is the subject matter similar? Rightward arrow yes. Congressional inaction. In the Taft-Hartley Act, Congress already excluded a provision, which would have allowed for the president to take action in the same way he did in this case. Does their silence on the issue mean anything? Jackson's concurrence. Presidential powers are not fixed, but fluctuate, depending on disjunction or conjunction with those of Congress. 3 categories. President acts pursuant to express or implied authorization of Congress. President's authority is at a maximum. Action would be supported by the strongest of presumptions and brought judicial interpretation. If this is unconstitutional, it is likely because the federal government as a whole lacks the power. President acts in absence of either a congressional grant or denial of authority. Zone of twilight. He and Congress may have concurrent authority or distribution of authority is uncertain. Can only rely on his own dependent powers. Congressional indifference may sometimes enable measures on independent presidential authority. Test on power will depend on the imperatives of the event, e.g. emergency, and contemporary imponderables. Rather than abstract theories of law. President acts in contradiction with and takes measures incompatible with the express or implied will of Congress. President's power is at its lowest ebb. Can only rely on his own constitutional powers, minus any constitutional powers of Congress over the matter. Courts can sustain exclusive presidential control only by disabling Congress from acting upon the subject. 2. Presidential foreign powers. International agreements overview. Treaties, agreements between the United States and another foreign country, negotiated by executive, ratified by 2/3 vote of Senate. Self-executing, goes into effective immediately, e.g. most military treaties. Non-self-executing, binds United States, but doesn't have any internal operative effect until internal legislation is passed by Congress. X. Treaty binding U.S. to notify embassies of foreigners' arrest is not binding on states because it is not self-executing. X. Copyright treaties have no effect until they become part of statutes. Most formal and significant. Treaties are invalid if they conflict with the Constitution. State laws that conflict with treaties are invalid. If there is a conflict between treaty and federal statute, the most recently adopted controls. Executive agreement, agreement between U.S. and foreign nation that is effective when signed by President and the head of the foreign nation, approval through simple majority in both houses of Congress. President is given more leeway in foreign relations because the U.S. needs a single voice portrayed to the world. There are no express powers in the Constitution related to foreign powers, whereas domestic powers are outlined because the states needed to be protected from the federal government. States have no interest in foreign relations though. Goldwater v. Carter. Facts: Carter unilaterally terminates the 1954 treaty recognizing Taiwan. Holding: non-justiciable political question that the court shouldn't be deciding. No majority. Comparison to Youngstown. Constitution only gives Congress the right to ratify treaties, not to abrogate them. Different than Youngstown because this is a dispute between two co-equal branches of government. Justiciability. Standing. Not addressed, but unlikely after rains. Ripeness, Powell. Difficult to see why this is a ripeness problem. What would Senate do differently? Political question, Rehnquist. Question presented: does President have unilateral authority to change treaties? Compare with Baker and Nixon. Curtis Wright. Facts: Curtis Wright conspired to sell arms to Bolivia in violation of a joint resolution of Congress, which authorized the president to ban sales of arms to countries involved in a border dispute between Bolivia and Paraguay. President immediately issued executive order banning sales after joint resolution was passed. CW indicted for conspiring to sell, claimed joint resolution was invalid delegation of legislative power to the executive. External sovereignty was never owned by the states, but by a union of the states. Investment of the federal government with the powers of external sovereignty didn't depend on F. Grants of the Constitution. Only the president can act as the representative of the nation. Sole organ of the federal government in the field of international relations. Congress and President agree. Joint resolution and executive agreement issued on the same day. No separation of powers issue. Executive power at its maximum. One voice. Dames and More v. Reagan. Facts: temporary freeze on Iranian assets, an emergency rationale, when hostages were held hostage at the embassy in Tehran. Additionally, all claims funneled into arbitration. Not going to ever expire and therefore cannot be justified with the emergency rationale supporting the temporary freeze. Holding: suspension was within the authority of the executive because the action was necessary to the resolution of a major foreign policy dispute and Congress acquiesced. Tenor is favorable to the president. Failure to authorize the president in re to foreign affairs does not constitute disapproval. Although we assume that Congress intentionally did not give the president the power if closely related legislation doesn't give the president the power. We do not know what closely means, subjective standard. No contrary legislative intent. Similar deals were made in the past by the president, history of congressional acquiescence. No one has brought a similar challenge. This has no bearing on the constitutional question. Weaker than the issue of congressional silence. International Claims Settlement Act of 1949. Congress said we expect there to be more deals. Other deals are continuing acceptance which the courts asserts demonstrates further support by Congress of the president's power. Specific deals with specific countries suggests that Congress wants to explicitly pass statutes for each particular issues. Unclear what Congress would have done or should have done in situations where they are silent. If Congress doesn't pass a statute, but acquiesces, doesn't mean anything in terms of separation of powers. Separation of powers is for everyone, the people, and Congress cannot waive or acquiesce to a violation of the Constitution. Hard to rule on a slight constitutional issue when everyone but Dames agrees that the deal was a good idea. Hard to know what this case stands for. Similar to Youngstown in many ways, but with the opposite result. Maybe silence from Congress does have some meaning though. 3. Presidential power in the time of war. Hamdi v. Rumsfeld. 4. Executive privilege and immunity. United States v. Nixon, 407-413. Facts: former Nixon aides indicted and Nixon named unindicted co-conspirator, Watergate. Standing: although special prosecutor is part of the executive, he can still sue the president because he is separate from the president. AG appointed by president and confirmed by the Senate. Federal regulation from AG's office gives special prosecutor power. Could, but they didn't revoke the regulation. Extraordinary improprieties was only way special prosecutor to fire him. Set up separately from the executive. Not longer solely within the executive branch, some other interests. Courts. Public. Other defendants. These are adverse parties. Absolute vs. Qualified executive privilege. Nixon argues that absolute privilege is necessary to preserve candid advice of those speaking with the president. Privileges exist because there are interests that are more important than the